The Subcommittee on Courts, the Internet, and Intellectual Property will come to order. I'm going to recognize myself for an opening statement, then the ranking member, Mr. Berman of California, for an opening statement. Then I want to represent the gentleman from California, Mr. Issa, for comments as well, because he is the author of a resolution that was approved on the House floor recently to deal with the subject at hand. I also want to compliment the gentleman from California, Mr. Issa, because I believe, with the exception of the chairman and the ranking member, that he has the best attendance record on this subcommittee of anyone. And that is both appreciated and will be remembered. I'll recognize myself for an opening statement. The evidence continues to show that the government of the People's Republic of China is engaged in a long-term effort to steal sensitive and proprietary technologies from U.S. industry. Last week, federal judges in Los Angeles ordered Chi Mak, an electrical engineer who worked as a defense contractor, and his brother Tai Mak, who also is in the Chinese military, to be held without bond in a case prosecutors believe could be among the most damaging cases of Chinese technology spying. In court papers, Chi Mak has reportedly admitted passing restricted data for 22 years, including sensitive information on the DDX destroyer, the Aegis weapon system, and a U.S. study that reveals the methods to be used by U.S. warship personnel to continue operating after being attacked to Chinese military intelligence handlers. This kind of technology spying and theft of intellectual property pose serious threats to our country's long-term economic and national security interests. No two governments are more adept at exploiting U.S. weaknesses in protecting technology than the governments of China and the Russian Federation. U.S. policy is motivated by a sincere desire to encourage these governments to respect individual rights, including the right to profit from the legitimate use and licensing of intellectual property rights. Our hope is that the Chinese and Russian governments will ultimately develop into reliable and dependable allies in the fight to protect intellectual property rights. But that hope must be grounded in reality and not motivated by wishful thinking. Unfortunately, there is little in the present record to indicate a sincere desire by the political leadership of these nations to respect the rights of U.S. intellectual property owners. In numerous international and bilateral agreements, China and Russia assume the duty to provide adequate and effective enforcement of intellectual property rights in return for the United States and other nations lowering trade barriers to their goods. The political leadership of each nation has prospered by being permitted to reap the benefits of international trade without being held accountable for their own commitments. Their record stands in stark contrast to the countless assurances, guarantees, and commitments to honor their obligations that have been made to the most senior officials of the United States government. One of the most offensive examples of intransigence was reported in the December 1st edition of the Moscow Times. In an article entitled, "Envoy Licensed DVDs Cost Too Much," end quote, Alexander Kotenkov, who is President Putin's representative in the Russian parliament's upper chamber, stated at a conference, quote, devoted to the fight against piracy, that he often purchased illegally made discs for plane trips, paying the equivalent of $3.12 for a DVD that contains 5 or 6 films. President Putin's representative went on to blame copyright owners for piracy by stating that Russian citizens are not at fault for being unable to buy licensed discs because the cost of legitimate discs are too high. I am confident, in connection with any future consideration of Russian accession to the WTO, the United States Congress will consider the extension of permanent normal trade relations with Russia. In the absence of a real, sustained, and verifiable commitment by the highest levels of the Russian government to protect the legitimate rights of intellectual property owners, I will continue to oppose U.S. support for the extension of PNTR and for Russia's admission to the WTO. I have no intention of watching while Russia becomes the next China, a result that I am concerned could ultimately lead to an erosion of U.S. public support for the WTO and the rules-based trading system that it was intended to implement. Our witnesses today will bring the subcommittee up to date on the developments that have transpired since May 17th, when this subcommittee held back-to-back hearings on Chinese and Russian IP theft. That concludes my opening statement, and the gentleman from California, Mr. Berman, is recognized for his.
Thank you very much, Mr. Chairman, for scheduling this hearing on international intellectual property piracy. I actually hope the subcommittee can institutionalize the practice of having at least one hearing a year that focuses on international trade and products protected by intellectual property rights. I particularly want to thank you for inviting Joan Borston to testify. She's a long-standing good friend, a constituent, and has a very compelling story. She brings a valuable perspective to the hearing, that of an individual American entrepreneur whose business has been dramatically impacted by a foreign government's sustained campaign to steal her rights to intellectual property. Because of the massive copyright piracy that occurs daily in China and Russia, the sales of black market goods cause an annual loss of revenue to American creators that is truly staggering. According to the International Intellectual Property Alliance, piracy rates in the copyright industries range from a low of 70% to a high of 95%, and American industries annually lose over $2.5 billion in China and almost $2 billion in Russia. But it is not only the copyright industries, entertainment, software, book publishing, etc., that suffer. We could probably have an entire hearing only on counterfeiting of motorcycle parts, purses, and pharmaceuticals. No industry is immune from the endemic intellectual property violations occurring in these two countries. The problem in both China and Russia is similar. While the laws may be on the books, actual enforcement of those laws is sorely lacking. Few criminal prosecutions have taken place, and even fewer sentences have been meted out. There's currently no true deterrent for the pirates. In fact, piracy has become the foundation for new businesses that export these black market goods. The one effective tool the current administration has to incentivize the Chinese government to address its piracy problem is pursuing a WTO case. At the last hearing on this issue, the USTR testified that they were committed, quote, committed to ensure that China is compliant with its obligations, and we will take WTO action if, in consultation with you and with our industry, we determine that this is the most effective way to fix the problem that we are resolved to fix, end of quote. When I asked whether 6 months would be a reasonable time frame to reach a conclusion, the answer was that it could be. So here we are 6 months later, and I'm looking forward to an update from that office. Furthermore, have additional avenues for mitigating the effect of piracy in China been explored by the current administration? Currently, the Chinese government engages in vast restrictions on market access for American copyrighted goods. They restrict the number of American films that can be shown, severely curtails the right of our companies to do business in their country. These barriers make the impact of piracy that much greater and virtually impossible for our companies to counteract piracy. With Russia, there is still some leverage because they have not joined WTO yet. I took note of the chairman's comments in his opening statement on this subject. A number of months ago, I, along with a number of other Democrats, wrote Ambassador Portman advising him, and these were Democrats who are inclined on a number of occasions, have been willing to support free trade agreements. We wrote a letter to Ambassador Portman advising him that in order to obtain our support for any future trade agreement, we would have to be assured that the lesson taught from allowing China to join the WTO without provision for adequate enforcement against intellectual property violations has been learned. In fact, just last week, IIPA submitted comments for the Special 301 out-of-cycle review on Russia. It's not encouraging news. Quote, in short, Russia is not complying with its commitments to provide adequate and effective copyright protection and enforcement, end of quote. Furthermore, the House, in a bipartisan vote, I believe that was the gentleman from California, Mr. Iss's resolution, recognized Russia's failure to adequately protect intellectual property and cautioned that without change, they are at risk of losing GSP benefits and accession to the WTO. The last time we discussed the complexity of denying GSP benefits to a country, a process which requires consultation of most agencies within the executive branch. It's clear that in Congress we all agree that this situation is quite outrageous and that a country that flagrantly violates American intellectual property rights should not receive GSP duty-free benefits. So I ask, since the last hearing, has there been any movement on the status of Russia's GSP benefits? If motivated, these countries can protect intellectual property rights. When piracy hurts the Chinese interests, the Chinese government has been motivated to step in. When knockoffs of the Beijing Summer 2008 game logos on T-shirts were being sold, the markets were quickly cleared. In short, China can deal with this problem if it has the political will, and when it has the political will. In Russia, it seems incredible that the Russian government actually controls the facilities and land on which many of these pirate optical disc plants operate. How can it simply do nothing to shut down the plants operating on these government-run installations? I'm looking forward to the hearing from the witnesses to learn what benchmarks or timelines have been established to help guide a decision on a WTO case against China, the withdrawal of GSP duty-free benefits from Russia, and whether Russia is aware that they will be denied admission to the exclusive WTO club unless the piracy problem is addressed. I'm looking forward to hearing about other steps that are being taken to protect American creativity. Thank you, Mr. Chairman.
Thank you, Mr. Berman. The gentleman from California, Mr. Issa, is recognized for his comments.
Thank you, Mr. Chairman and Ranking Member Berman. Thank you for your leadership in seeing that the resolution, which had to be pushed through the Ways and Means Committee, saw the floor and certainly showed the administration, in addition to the Russians, that we are determined not to make the same mistake we made with China. I personally voted in support of the permanent normalized trade and obviously led to WTO admission for China. That is a vote that I deeply regret. I'm a dyed-in-the-wool free trader, but free trade is about fair trade. Briefly, I wanted to echo some of the comments that the ranking member and the chairman made, which are, if you have countries which believe, support, and in fact participate in theft, it doesn't matter what their justification is. The truth is that Russia and China hide under the theory that they cannot afford, that they are poor countries, they cannot afford to pay that, as was said in the opening statements. The fact is Russia has become the #2, soon to be the #1 seller into Europe of counterfeit goods. Obviously, Russia believes that Europe can also not afford. Luxembourg, with a per capita GDP similar to the United States, cannot afford to pay a fair price unless, of course, Russia's making a profit on it. There's no question that this behavior is part of a culture in the old Soviet Union and the still technically communist China, that intellectual property is not real property and that, in fact, it is a right of the state. That attitude and the legislation and the enforcement have to be changed. I believe that with the chairman's leadership, that we can continue to echo the message to the administration, trade representative here today, that we shall not, under any basis, allow for accession to the WTO, which I do have to disagree with the ranking member slightly. I'd like to say it was exclusive, but with over 140 members, the truth is Russia stands out by its absence as a country prohibited, rightfully so, prohibited from entering this no longer so exclusive club because of their action. Their action is reprehensible, and I'll close with this. Less than 6 months ago, I was in Russia, and I've been assured by a group that was there over the break, it's still the same. If you can drive the main streets of Moscow and see them offering MPEG-4, MP3, formats for movies and for music that are not offered from the makers in their original form on the main streets in large neon signs, and of course offering an opportunity to buy Star Wars long before it was out on DVD. It is very clear that they are unapologetic for their theft of intellectual property, and as Mr. Berman, I believe, noted, they don't have a problem at all stealing other property from us in the defense industry and, in fact, in every area of manufacturing. And I thank the chairman and the ranking member.
Would the gentleman yield?
I'd be glad to yield.
On the issue of the exclusivity, it reminds me of the Groucho Marx line, why would you want to get in any club that would take you?
To have you as a member. Absolutely, and that would I yield back.
Thank you, Mr. Issa. It's nice to have a united front up here. Before we hear from the witnesses, I'd like to ask you to stand and be sworn in. Would you please raise your right hand? Do you swear that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God? Please be seated. Our first witness is Chris Israel, who serves as the coordinator for international intellectual property enforcement. Mr. Israel was appointed to this newly created position, which is housed at the U.S. Department of Commerce on July 2005 by President George W. Bush. In this capacity, Mr. Israel is tasked with coordinating and leveraging the resources of the federal government to improve the protection of U.S. intellectual property at home and abroad. Before accepting his current position, Mr. Israel served in a variety of assignments at the Department of Commerce, many of which focused on advancing U.S. innovation and technology leadership. I am told that today's testimony will mark the first time that Mr. Israel has testified before a committee of Congress since accepting his new responsibilities. His ability to ensure the development of a sustainable and comprehensive national and international enforcement policy for the protection of U.S.-based intellectual property rights is of vital and continuing interest to this subcommittee. Mr. Israel received his BA from the University of Kansas and his MBA from the George Washington University. Our second witness is Victoria Espinel, who is the Acting Assistant U.S. Trade Representative for Intellectual Property in the Office of the United States Trade Representative. In that capacity, Ms. Espinel serves as the Principal U.S. Trade Negotiator on Intellectual Property. Ms. Espinel's office chairs the Intra-Agency Committee that conducts the annual Special 301 review of international protection of intellectual property rights. The latest report was published on April 29, 2005. Subsequent to its publication, Ms. Espinel appeared before the subcommittee to deliver testimony on the subjects of intellectual property theft in China and Russia. She will be providing the subcommittee with an update on developments as well as a status report on the substantial challenges that remain. Ms. Espinel holds an LLM from the London School of Economics, a JD from Georgetown University, and a BS in Foreign Service from Georgetown University School of Foreign Service. Our third witness is Eric H. Smith, who serves as the president of the International Intellectual Property Alliance, a private sector coalition of 7 U.S. trade associations, which is based in Washington, D.C. IIPA represents over 1,300 companies that produce and distribute materials protected by copyright laws throughout the world. A founder of IIPA, Mr. Smith frequently serves as the principal representative of the copyright industries in WTO, TRIPS, and free trade agreement negotiations. Mr. Smith has a JD from the University of California, Berkeley, a BA from Stanford, and an MA from the School of Advanced International Studies at Johns Hopkins. Our final witness is Joan Borston, who is president of Films by Jove, Inc., a California-based production and distribution company that acquired worldwide rights to much of the animation library of Moscow's, Soyomulfilm studio in 1992. Ms. Borston received her BA in Comparative Literature from the University of California at Berkeley and her MS in Bilingual Education at USC. Welcome to you all. We have written statements from all the witnesses on this panel. Without objection, their complete testimony will be made a part of the record. As you all know, we trust that you will limit your testimony to 5 minutes, which we look forward to, and Mr. Israel will begin with you.
Thank you, Mr. Chairman. Chairman Smith, Ranking Member Berman, and members of the committee, I'm pleased to be able to be here today to join you and my counterparts on this panel to discuss the challenge of international intellectual property rights enforcement. I want to first thank the committee for their continued support and leadership on issues concerning the protection of intellectual property. I look forward to the opportunity to work together to ensure that the heart of America's thriving innovation economy, its intellectual property, is effectively protected around the world. Combating piracy and counterfeiting is a top priority for the Bush administration. President Bush has consistently raised IP enforcement with foreign leaders, placed it on the agenda of the G8, and made it a key part of the recent U.S.-EU summit. He has also discussed our ongoing concerns with leaders of critical markets such as China and Russia. In addition, he has directed his administration to address the issue actively, aggressively, and with a results-oriented approach. The reasons IP enforcement is a priority for this administration are very clear. Few issues are as important to the current and future economic strength of the United States as our ability to create and protect intellectual property. Enforcement of intellectual property also carries great consequence for the health and safety of consumers around the world because fake goods don't just hurt business, they hurt people. Finally, the theft of American intellectual property strikes at the heart of one of our greatest comparative advantages, our innovative capacity. The Office of International Intellectual Property Enforcement is located at the Department of Commerce, and I report to Secretary Gutierrez. We also work under the leadership of the White House, and we have been met with tremendous cooperation from all federal agencies that contribute to our overall IP enforcement efforts. A very critical element of our overall coordination is the strategy targeting organized piracy, the STOP initiative, launched by the Bush administration in October 2004. This initiative brings together USTR, Commerce, Justice, Homeland Security, and the State Department. STOP has yielded tangible results and received attention around the world. The STOP initiative and our new Office of International Intellectual Property Enforcement allows us to deliver a clear message. The United States takes the issue of intellectual property enforcement very seriously. We are leveraging all of our resources to address it, and we have very high expectations of all of our global trading partners. As this committee clearly understands, the problem of global piracy and counterfeiting exists in many industries and countries and demands continuous attention. With finite resources and seemingly infinite concerns, how we focus our efforts is critical. The Bush administration is focused on 6 key priorities. First, we are working to empower America's innovators. Through specific tools and broad education efforts, we are getting the word out to American businesses that they must be aggressive and proactive in protecting their rights. Secondly, we are focused on preventing counterfeit and fake goods from penetrating our borders. This means casting a wider net, utilizing technology, and working with our trading partners to share information. Third, we are working to prevent fake and counterfeit goods from corrupting legitimate supply chains. We have worked closely with the Coalition Against Counterfeiting and Piracy to develop voluntary guidelines companies can use to ensure their supply and distribution chains are free of counterfeits. Fourth, U.S. law enforcement is leading efforts to dismantle criminal enterprises around the world that steal intellectual property. The Justice Department has pursued numerous operations targeting criminal organizations involved in online piracy and trafficking in counterfeit goods. Fifth, we are working with our trading partners to build international support for IP enforcement. Through the Joint Committee for Commerce and Trade, the JCCT, for example, we have worked extensively with China to address rampant IP concerns, and just last week, we reached an agreement to work much more closely with the European Union to combat global piracy. Lastly, we are educating other governments about intellectual property rights and how important IPR is to the global economy. To date, over 100 IPR enforcement projects and 290 IPR technical assistance projects have been conducted around the world. Mr. Chairman, the Bush administration is committed to stopping intellectual property theft and providing businesses with the tools they need to flourish in a global economy. As I work to coordinate the U.S. government's efforts, and with your continued support and the partnership of this committee, we will be able to do even more on behalf of American innovators, researchers, entrepreneurs, artists, and workers. We must take advantage of the opportunity to work together to better protect the knowledge industries of today so that we may continue to see the innovations and growth of tomorrow. Thank you, Mr. Chairman.
Thank you, Mr. Israel. Ms. Espinel.
Thank you. Chairman Smith, Ranking Member Berman, and members of the committee, thank you for the opportunity to address the important issue of the international protection and enforcement of intellectual property. Stopping counterfeiting and piracy and protecting our right holders is a top priority of this administration and of USTR. My remarks will focus on China and Russia, but time permitting, I would also like to provide you with a brief overview of our other activities to fight counterfeiting and piracy. Turning to China, the protection and enforcement of IP remains a top issue in our bilateral trade relationship with China. It is an issue that has been raised at the highest levels of government with the Chinese by both Ambassador Portman and by President Bush. As you know, each year USTR issues a special 301 report that catalogs the IP problems of the world's worst offenders. In 2004, because of our level of concern at China's continued lack of progress, USTR initiated a more intensive review of China's IP regime known as an out-of-cycle review. On April 29th, USTR reported the results of that review. I described the results of the review and the actions we announced that we would take in my earlier testimony. Today, I would like to update you on the progress that has been made since then on the actions that we set out in the 301 report. First, we committed to investigate potential WTO dispute settlement cases. In the 301 report, we announced that we would be working closely with our industry with a view towards WTO dispute settlement. Cases at the WTO require extensive research and data collection. We have been working closely with our industry to develop the information and have, for example, sent a USTR legal team to China to meet with industry enforcement experts on the ground. We anticipate that those industries that have been working closely with us will continue to do so. We appreciate greatly the Chairman's support of this partnership. Our timetable for determining whether or not a WTO case against China is the most effective approach is dependent on the effectiveness of these efforts. Second, we elevated China to the priority watch list as an indication of our significant level of concern. Third, we pledged to intensify work through the JCCT IPR working group. Since April, we have had 3 meetings of the JCCT and have seen progress at these meetings. My complete testimony sets out a number of commitments made by China at the July JCCT following the experts meeting in May and our elevation of China to the priority watch list. I will highlight a few of them. China agreed, among other things, to increase criminal prosecutions, to reduce exports of infringing goods, to establish an IPR ombudsman in the Chinese embassy to assist small and medium-sized companies in particular, to join the WIPO Internet treaties in 2006, and to clarify some deficiencies in the judicial interpretations. Since July, in order to move these commitments forward, China has done several things, including making a proposal for customs cooperation. They have explained to us their process to ensure legal use of software by the government. They have sent us Internet regulations in order to come into compliance with the WIPO Internet treaties and have committed to work with us on them. They have told us that the IPR specialist to help small and medium-sized businesses will be in Washington by the end of this year. And they have been working on regulations to transfer administrative cases over to the criminal process as part of the effort to increase criminal prosecutions. We have also seen some increased enforcement, particularly against counterfeiting, for example, in this year's Mountain Eagle campaign. But we have made clear to China that we need sustained enforcement and that annual enforcement campaigns will not be sufficient. Fourth, I would like to highlight the TRIPS transparency provision commitment that we made. We announced that we would be filing a formal request under Article 63 of the TRIPS agreement, and we did so on October 26th. This request seeks additional information on China's IP enforcement efforts. In an example of our work to enhance international cooperation, we were joined by Japan and Switzerland, who submitted simultaneous similar requests. These requests seek detailed information from China on its reported IPR enforcement efforts. China's response to these requests, anticipated in early 2006, will be a test of whether it is serious about resolving the rampant IP infringement throughout its country. Turning to Russia, enforcement in both the copyright and trademark sectors continues to be a significant problem in Russia. As a result, Russia is designated as a priority watch list country in the Special 301 report, and an out-of-cycle review is being conducted this year to monitor progress. We are also continuing interagency review of a petition filed by the U.S. copyright industries to withdraw some or all of Russia's GSP benefits. USTR and other agencies have been and will continue to be very engaged with the Russian government at all levels to develop an effective intellectual property regime and strengthen enforcement in Russia. Intellectual property has been raised as a priority issue by Ambassador Portman and by President Bush. We are working on IP issues in Russia on a number of fronts, including in the context of Russia's WTO accession negotiations. We have made it clear to the Russian government that progress on intellectual property will be necessary in order to complete the accession process. Our work has brought about some improvements, particularly with respect to the content of Russia's laws, but enforcement of these laws is critical. We have seen some recent indications of progress, and we are monitoring to see whether or not Russia sustains and increases these efforts. We will continue to push and have made clear to Russia that we need concrete results. USTR has a number of other tools at our disposal. I would like to give a very brief overview of these. As you know,
Ms. Espinel, I'm afraid your time has expired. We'll look forward to hearing the rest of your testimony when we ask you questions, if that's all right.
thank you.
Thank you. Mr. Smith.
Why don't you turn on your mic?
Let's see.
Got it? Yeah. Representing now over 1,900 U.S. copyright-based companies, thank you once again for the opportunity to appear here to review the record of China and Russia on enforcing their copyright laws to reduce among the highest piracy rates in the world. I'm afraid anything I add here won't even approach the eloquence with which the chairman and the ranking member and Mr. Issa described the endemic piracy problems that we face in these two countries. We reported to you last May that our situation in both these countries was dire at best. Our industries were losing at least $2.5 billion a year in China, $1.7 billion in Russia. Piracy rates were 90% in China and between 70 and 90% in Russia, depending on the sector involved. You've asked us to give you a report card on progress over the last 6 months. We regret to report that there has been negligible progress in China, and the situation in Russia has actually gotten worse. Neither country has yet found the political will to act. Let me turn first to China. In my written statement, we outlined what has happened, or more accurately, not happened in the last 6 months. Some report that the government is showing greater awareness of piracy and is being more cooperative. This is progress, no question. But have the Chinese authorities commenced a barrage of criminal cases against pirates? No. Have they sought to provide greater market access? China is the most closed market in the world to copyright-based industries. The answer, again, is no. In fact, the U.S. government in the last JCCT round was told flat out no. There would be no market liberalization in these sectors. In my written testimony, and Ms. Espinel's as well, we detail what happened at the July 2005 JCCT meeting. There was some progress made, but in our view, most were in the nature of future commitments, not what we really seek, a report on specific actions being taken to, quote, significantly reduce IPR infringements, unquote. We are continually frustrated by the lack of transparency in the Chinese enforcement system. One of the reasons that USTR went to the Article 63 process in the TRIPS Council was to hopefully get a real understanding of how the Chinese system works by getting meaningful facts about all the vast numbers of cases they cite to us. At the recent IPR working group meeting in November in Beijing, it was reported to us that the Ministry of Public Security provided statistics on some of its enforcement actions. They sound impressive, but there was no report on how many copyright cases were brought, how many persons were convicted for piracy of U.S. copyrighted works, or on what penalties were meted out. We have no alternative but to conclude that the number of cases brought was very close to zero. And to the best of our knowledge, there have only been 2 convictions for piracy of U.S. copyrighted works under Article 217 of the criminal law since China joined the WTO, and none that we are aware of in the last 6 months. Our view is that China's failure to bring criminal cases against copyright piracy on a commercial scale, the TRIPS standard, puts it in violation of its obligations under the WTO TRIPS agreement. We also believe that China's criminal law on its face is in violation of TRIPS. Not being able to do business in the Chinese market is deeply frustrating to our companies. It is inexcusable that China continues to permit the wholesale theft of U.S. intellectual property, a key export of our country, while continuing to enjoy the benefits of our open market for Chinese goods. So open that China enjoyed a $162 billion surplus with us in 2004. As we noted earlier, this is an issue of political will, and we have not seen it yet. Turning to Russia, a market which has deteriorated for us in the last 6 months. Some salient facts. In the last 6 months, Russia has added at least 8, and by some accounts more, optical disc plants to the 34 we reported last May. 9 of these plants, and maybe up to 18, are located on the facilities of the Russian government, as was described. Pirate optical discs forensically sourced from Russia have been found in 27 countries. We have asked the Russian government to inspect these factories, seize pirate product, seize the equipment used in these infringements, and prosecute the plant owners while imposing deterrent penalties that would place every Russian plant owner and their associates in real jeopardy. This has just not happened. In recent weeks, the Russian authorities reported taking 9 raids against OD plants. This is positive, but the results are telling. Much of the seized material ended up back on the streets. No equipment was seized. We believe that most of these plants continue to operate. This has been the typical situation in 2004 and so far in 2005. We know that over the years, a few people employed by these plants were prosecuted and convicted, but virtually all have received suspended sentences. There is simply no deterrence in the Russian system, and until there is political will to change that, we cannot expect much change. Fortunately, we have ample tools to help Russia hopefully find that political will to enforce the law. In passing House Congressional Resolution 230 by a near unanimous bipartisan vote in the House of Representatives on November 9, thanks to Mr. Issa and all of you, the administration has been delivered a clear message. Until Russia takes effective enforcement action to reduce this piracy, it should not be admitted to the WTO and receive the trade benefits accorded WTO members. We cannot make the same mistake that was made with China, permitting Russia to enter the WTO without undertaking meaningful and WTO TRIPS-compatible enforcement. It has also sent a clear message that Russia should not be eligible for over $600 million, that's January to September 2005, in GSP benefits. IIPA's GSP petition is 5 years old. It has not been acted on, and piracy has gotten worse in Russia. IIPA just testified at another GSP hearing looking into Russia's eligibility. We asked again for benefits to be withdrawn. It's now time to act and for the administration to remove these benefits. The U.S. government also has huge leverage under Special 301. IIPA has recommended that Russia be designated a priority foreign country after the ongoing out-of-cycle review. If no actions are taken, Special 301 permits the levying of retaliatory sanctions against such named country. We cannot allow Russia to continue to feel invulnerable at the same time as they do nothing to halt massive theft of our intellectual property. Thank you again, Mr. Chairman, for showing such a great and abiding interest in nurturing the creative and innovative individuals and industries that have become so important to our culture, our technological future, our economic growth, and to job creation. I'd be pleased to answer any questions. Thank you.
Thank you, Mr. Smith. I have to observe that I noticed, Mr. Smith and Ms. Borson, that you both went to Berkeley, and it's just nice to see 2 graduates of Berkeley be in favor of any kind of property rights, particularly intellectual property rights. And that's not really a slight, but goes more to the reputation, perhaps, of one of the best institutions in the country. Ms. Borston.
Chairman Smith, Congressman Berman, and other distinguished members of the subcommittee, I want to thank you for the invitation to appear before you again. Despite 3 U.S. federal court decisions in our favor, my company, Films by Jove, continues to be threatened with the loss of our investment by the Russian government. In May 1992, Films by Jove acquired rights to distribute internationally an award-winning library of more than 1,200 Soviet animated films. Most of these films were little known outside the former Eastern Bloc. Our contract required that we restore and reformat the films for the international market and that we pay our Russian partners significant acquisition fees and profits. Our success drew the attention of the Russian Federation officials, who wanted to bring the lucrative business that we developed under their own control. In 1999, the Russian government deliberately formed a new state-owned animation studio with the same name as the studio from which we had licensed the rights back in 1992. In 2000, this state-owned studio, backed by the Ministry of Culture, joined forces against us as a third party in a lawsuit we had initiated in the New York federal court to end illegal video duplication by a major Russian-American video pirate, a convicted felon. The new studio told Judge David Traeger that it was the sole legitimate copyright holder of the animated films and that we were the pirates. In August 2001, Judge Traeger concluded that we had signed our 1992 contract with the only possible copyright holder of the animated films. The following year, the Russian studio requested that Judge Traeger reconsider his ruling on the basis of a new decision by Russia's highest commercial court. That ruling canceled, without explanation, certain lower court decisions on which Judge Traeger had relied. To counter this step, we presented the court with a confidential document which provided details of a secret meeting at the Kremlin about securing the animation rights for the new studio. The secret meeting was attended by a representative of the Office of the Chief Justice. It was also attended by the Minister of Culture, his 2 deputies and their lawyer, representatives of the State Property Ministry, the State Prosecutor's Office, the Russian Patent Bureau, the Presidential Administration, and the director of the new state-owned studio. At the meeting, the Deputy Prime Minister assigned the Chief Justice the task of making sure the courts ruled in favor of the state. The last time I testified, we were still waiting for Judge Traeger's decision. In April 2003, he denied their request for consideration, writing, quote, "It is apparent that the High Arbitrage Court's decision was strongly influenced, if not coerced, by the efforts of various Russian government officials seeking to promote state interests. Under these circumstances, the High Court's decision is entitled to no deference." 9 months later, the Prime Minister of Russia signed a directive, retroactively amending the 1999 directive that had created the new state-owned studio, now to include animation copyrights. According to both Soviet and post-Soviet laws, the state did not have those copyrights to give, either in 1999 or in 2003. The state-owned studio again petitioned Judge Traeger for reconsideration. In their brief, attorneys for the state-owned studio warned Judge Traeger that the Prime Minister's directive, quote, "strongly suggests that the Russian government is concerned about what has happened in this U.S. court." In November 2004, Judge Traeger again declined reconsideration, writing, "It would contradict the very principles at the foundation of the separation of powers doctrine to allow a foreign state to engage in activities that the United States courts would not tolerate from the U.S. legislature." The pirates settled. The state studio did not appeal, but the Russian government continued its efforts against us. Indeed, their recent actions have been most contradictory. One moment they propose settlement, and the next moment they resume obstructionism and hostility. In October this year, we signed a memorandum of understanding by which the new studio recognized our 1992 contract and its amendments. 1 month later, the Russian side suddenly began to demand additional documents in what we fear might turn out to be a renewed challenge to our rights. We've recommended numerous times to the Russian government that if it is so important for the animation library to be controlled by a Russian state-owned organization, they should come to the negotiating table and buy us out of our contract. Despite the difficulties that I have outlined, since Judge Traeger's decision, there has been progress in building protection for intellectual property rights of U.S. investors in Russia. It is now quite possible that in the future, U.S. companies harmed by Russian non-enforcement of their intellectual properties will be able to use U.S. courts to obtain redress of their grievances. Recently, both the Second Circuit and the Colorado Supreme Court reversed lower court decisions that had found the Russian courts to be adequate alternative forums for property disputes. I urge this committee and Congress not to underestimate the ruthlessness and implacability of Russian efforts to undermine property rights, especially intellectual property rights. I want to thank the subcommittee for giving me the opportunity to testify today, and I'll be happy to answer any of your questions.
Thank you, Ms. Borston. Mr. Israel, let me direct my first comment to you, and that is, I think it is worthy of emphasizing a couple of figures that you used in your prepared testimony. And in fact, I've used similar figures when I've made speeches on this subject as well. The first is that United States intellectual property industries account for over half of all U.S. exports and represent 40% of our economic growth. The figure I've been using is actually 30%, and I just wondered what your source was for the 40, which I like better.
Thank you, Mr. Chairman. I'd be happy to provide you the specific footnote to that. I believe that's a study that was done by the U.S. Federal Reserve that looked at economic growth, I think, in the latter half of the 1990s. But on the 40% number, I'd be happy to follow up with you in the committee on.
Great. If you would, and would you do the same in regard to the estimated IP theft cost to United States businesses of approximately $250 billion annually? And, of course, the result in hundreds of thousands of lost American jobs, I'm familiar with that. But the $250 billion figure, I think, is again, eye-catching. And if you could give us the source on that as well.
We'll certainly do it.
Ms. Espinel, let me direct most of my questions to you today just because of your position. You say in your testimony that we are working on IPR issues in the context of Russia's WTO accession negotiations. We have continuing concerns that Russia's current IPR regime does not meet WTO requirements. I assume today you would oppose the entry of Russia into the World Trade Organization based upon its current record, would you not?
I would certainly say that Russia needs to make considerable progress, as
Well,
we,
they're not-
including
you would-
Ambassador Portman, have made clear.
You would not consider them in sufficient compliance today to recommend their entry into WTO?
We believe more progress needs to be made.
I'm sorry?
We believe more progress needs to be made.
Okay. Do you have any ideas when that progress would be sufficient to justify their consideration?
Well, I suppose a lot of that depends on Russia. I mean, we're working very hard on the accession negotiations, obviously, but we've made it very clear to them that we need a good agreement in order to be able to complete the process.
Mr. Smith, in his testimony, raised or made 3 recommendations, and let me follow up on 2 of them. They overlap what I was going to ask you about. He says that IPA believes that after 9 years on the priority watch list, it is time for the United States government to take a different approach to Russia's inability or unwillingness to act. In this case, recommendation designate Russia as a priority foreign country after the ongoing out-of-cycle review by USTR. Why would you not so designate Russia?
Well, we would consider using all of the options that we have against Russia. I think we would consider not so designating Russia if we believe that progress is being made, or if we believe that designating Russia as a PFC would not be the most effective way to achieve what we want to achieve, which is progress in Russia.
The other recommendation was to deny Russia's eligibility to generalized system of preference duty-free trade benefits. When will that decision be made?
There is an ongoing review of GSP, which USTR is taking very seriously. There was a hearing,
And
actually.
is there a deadline for when that review will be complete?
The general GSP deadline, the regular GSP deadline, is June 30th for decisions. That doesn't necessarily, though, have to be Russia's deadline. There could be a decision made earlier than that.
So, that's good news. June 30th or perhaps before?
We would certainly anticipate that a decision would be made by June at the latest.
June 30th at the latest? Okay, good. And a question on China. If we are not using existing WTO trade dispute mechanisms against China, which is widely perceived as among the worst global IPR offenders, then of what value are the WTO mechanisms?
Well, I would say, I think even the threat of WTO dispute settlement, of which China is well aware, is an effective tool.
Well, the threats both to China and Russia just don't seem to be manifested in much of a change in their conduct. And so I think it's going to require tougher actions on your part, on the part of our government, if we're going to get the results that we want.
I think we would certainly agree that there's an enormous amount of work that remains to be done. We have seen some recent indications of progress with China and with Russia, although with Russia I would like to emphasize that those signs of progress are truly very, very recent. So obviously it's going to be critical to see if Russia has the ability to not just sustain that, but actually increase it significantly. With respect to WTO settlement or dispute settlement specifically with China, as you know, it is something that we are working quite closely with our industry to develop our WTO options. And if, as I said before, if we, in consultation with our industry and in consultation with you and the rest of Congress, believe that's the most effective way to address the problem, we will move forward.
Okay, I would guess you would get widespread support by Congress to take some strong actions. Thank you, Ms. Espinel. The gentleman from California, Mr. Berman, is recognized for his question.
Well, thank you very much, Mr. Chairman. First, Mr. Israel and Ms. Espinel, you've heard Ms. Borstein's sort of the story of her saga in dealing with the Russians and their sale of these copyrights, and then their refusal to acknowledge it, their creation of an entity to continue to produce them. I'm wondering if, following this hearing, you or your office is, I think Commerce only because commercial attaches in our embassy in Moscow, the trade representative, because your ongoing dialogue could, in addition to the broader issues, help the Russians understand the importance of this specific issue in terms of at least a good example of how they respect copyrights and contracts. Would you be willing to have your offices follow up in pursuing that?
Certainly, Congressman, and my understanding is that Films by Jove has worked with the U.S. Embassy in Russia.
Yes.
Previously, I know Ambassador Vershbow was personally engaged, and commercial officers in Russia have been engaged as well. We're certainly happy to take on board recent activity and any developing needs that the company may have for U.S. engagement and do any follow-up we can.
Great.
As would USTR.
Good. This issue about progress is being made. China, they made a number of commitments. Increase criminal prosecutions for IPR violations relative to the total number of IPR administrative enforcement cases. They agreed to do that. Have they?
In order to do that, well, one of the steps that they need in order to do that is to have regulations in place that will transfer cases that are put into the administrative system about which we have serious concerns.
Are those
not
regulations
sufficiently deterrent?
Are those regulations in place?
Those regulations are in process. They have drafted them. We are reviewing them. They are moving forward on them.
Reduce exports of infringing goods by issuing regulations to ensure the timely of transfer cases. That's what you're referring to for criminal investigation?
There are several regulations that China is in the process of drafting as a result of the commitments from the JCCT, including with respect to transfer of administrative cases to the criminal process, export regulations, and internet regulations in order to come into compliance with the WIPO Internet treaties.
And at this particular point, none of these regulations are in place.
None of these regulations are yet in place.
Improve national police coordination by establishing a leading group in the Ministry of Public Security responsible for overall research, planning, and coordination of all IPR criminal enforcement to ensure a nationwide enforcement effort. Have they created such a group in the Ministry of Public Security?
I believe that has been concluded.
Okay. 4, enhance cooperation on law enforcement matters with the U.S. by establishing a bilateral IPR law enforcement working group focusing on the reduction of cross-border infringement activities. Has that been done?
Yes.
Expand an ongoing initiative to aggressively counter piracy of movies and audiovisual products.
Yes.
It's been
It has. I
expanded.
mean, I should note, I suppose, that there have been some mixed results from that. There's been some very good results. The results of the campaign in Beijing were not as strong as we would have liked to have seen. The results in Shanghai and I believe Shenzhen were actually quite positive. But again, I would like to emphasize that China, whatever signs of progress there we consider to be obviously good, but nascent. I mean, what is critical is that they sustain them.
What do you have benchmarks in mind for determining whether the progress is real and meaningful and substantial? I sound like we're talking about Iraq, but I'm not. We're talking about in terms of dealing with the problem of piracy in a percentage context, a reduction, or in an absolute number context. Do you have some kind of benchmarks in mind for deciding whether or not there's enough progress to justify continuing not to bring a WTO case?
Well, I guess in my view, there are two sort of categories of benchmarks. One is the specific commitments that China has made to us and whether or not they follow through on those in terms of, for example, improving their legislation or putting certain processes in place. And the second would be result in terms of actually seeing piracy and counterfeiting reduced, whether that's measured by increased sales of our products or measured by industry's assessment of the piracy rates falling. But I would say both of those, I think, are important components to measure progress.
And on the latter, what have you seen so far? On the quantified benchmarks, the reduction in piracy, the increase in acquisition of legal goods.
I'm not aware that industry has done an overall survey since the last time I was before this testimony, so I don't have any new figures or statistics to cite.
Well, Mr. Smith, if you apply that quantifiable standard, what would you say about China at this point?
Well, for 2004, at least, the piracy rate went down a small notch in the recording industry, but stayed pretty constant for everything else. And we don't expect much of a change in 2005, simply because we haven't seen in our area the kind of criminal enforcement that the China's been promising for a long time now. We just haven't seen it.
Well, I think my time has expired.
And the gentleman's time has, in fact, expired, and the gentleman from California, Mr. Schiff, is recognized for his questions.
Thank you, Mr. Chairman. And really the question I had is the question that Howard concluded with. But I'd like to see if I can get a few more specifics on it, because I think both with respect to China and Russia, and for our own purposes, unless there are clear expectations expressed to China and Russia about what we would like to see happen, in Russia's case vis-a-vis WTO and GSP, in China's case whether there's an actual case filed on the WTO. My guess is, from my limited meetings with Chinese officials both there and here, they'll continue to tread water as long as they feel they can tread water. It won't injure the trading relationship, and I think the same is true of Russia. Unless they have clear benchmarks of what we expect, I don't think things are going to change appreciably. But I do think that if we set out clear benchmarks of what we expect, then we might get a change. And I know that you've asked the industry to go about doing the documentation to prepare for a WTO case. And I'm sure that will be useful, although the facts seem to be pretty overwhelming. If you can't make a WTO case in China, you can't make a WTO case anywhere. And it seems to me that this is really designed to buy time and to tread water a little bit. But again, I think unless we have a clear set of benchmarks of what we expect, and it might be measured in terms of reduction of piracy, I don't know that it can be measured in the sense of increased sales of our products. That doesn't seem like although a desirable metric, doesn't seem like a legitimate metric in terms of their piracy problems. But what more specific and quantifiable things either have you asked for or can you ask for where we can make a very, where China can be given the very clear alternative of meet these expectations or we'll support a WTO case, or in Russia's case, their extension. What are the clear metrics that either you have offered or that we can now offer?
Well, first I would say that I absolutely agree with you, that I think having clear benchmarks or a clear path forward is critical for China, Russia, and frankly for all the countries where we're facing this challenge, so they have a clear understanding of what we think is necessary in order for them to address that. With China and Russia, we have done that, I think, both at what I would describe as a macro level and a micro level. And we've made clear to China and Russia that we need to see improvements, and that improvements will be measured by seeing the piracy rates come down. We have, in addition to that, given them very detailed list of either improvements in legislation, administrative processes, other very detailed improvements they need to make to their overall system in order to make their system more effective. And we will be measuring progress both by decrease in piracy rates and by their ability to move forward on the very specific action items that we've given both of them.
Can you share with us, the chairman asked what the deadline was for determination on the GSP issue is June 30th. It has to be decided by June 30th, is that?
That is the general deadline for the GSP review processes that are outstanding. That's not specific to ISP, just specific to the GSP review process as a whole.
So it'll be on or before that point, you'll have to make a decision about whether to try to revoke GSP status. Can you let us know what criteria you've enumerated with the Russians so that we can hold you accountable and that we can together hold the Russians accountable? Because as we get closer to June 30th, there may be a decision made to wait till the next June 30th, which is a decision of sorts that we've made, I guess, over several years because we haven't taken action in this area. But it would be useful, I think, for us and for the Russians to know precisely what we expect of them. My impression, again, with respect to China, and it's probably similar to Russia, is that if we merely talk about improvement, they will give us a very good presentation about all the ways they've improved. And yet, at the bottom line, the piracy won't have changed very much. So either today or in written form, I'd really like to see what specifically we expect to take place before June 30th with respect to Russia, what specifically we expect China to accomplish in terms of number of criminal prosecutions or whatever standard is the right standard to use, so that we can encourage, foster, push a WTO case or any other kind of enforcement action so that we can get concrete results. Invite any of you to respond to that.
Congressman, I would add one insight based on something you brought up in the initial part of your question to Victoria, which is the sales of U.S. goods and services into these markets. I think is a very critical piece of evidence we need to review and we need to look at, and it's something that working with industry is the key vehicle that's going to present those types of results. When we talk to the Chinese about bringing their government infrastructure into an environment where they use legitimate and legal software, I think the most effective determinant of their progress on that, or one of the most effective determinants, is our leading American software companies who are actively looking to get into that market, having better results. The fact that the Chinese market is the second leading market, the second largest market for PCs in the world, but the 25th largest market for software in the world, obviously tells us that in between 2 and 25, there's a lot of piracy going on. So I do think it's important, and one thing we're trying to focus on doing is work with U.S. industry to get some indicators from them.
And I don't disagree with that. What I mean is that I don't know that we could tell China that unless we sell X amount of products in there, we're going to bring a WTO case for infringement. I don't know that we can show that causal effect, but I do think we ought to maximize our pressure to open the markets in China for exactly the reason you mentioned.
If I could just add to the specifics, particularly with respect to Russia, in terms of benchmarks that we're looking for, one thing that we've made very clear to Russia is that they have a massive optical disc piracy problem, and that we need to see the plants shut. But in addition to that, we need to see the equipment seized and destroyed so the plants can't reopen. There are raids and prosecutions, but we need to see people actually be put in jail. There does seem to be, again, this is recent, greater cooperation on the law enforcement side. It may be that the prosecutors are the weakest link in the system at this point in time. But I think both on the OD plans, on the optical disc plans, and on tackling the internet piracy problem that Russia has, those are two key items that we have made quite clear to Russia we see as priority issues that they have to get addressed.
Thank you.
Thank you, Mr. Schiff. The gentleman from California, Mr. Ice, is recognized for his questions.
Thank you, Mr. Chairman. I sit on the International Relations Committee in addition to the Judiciary Committee, and oddly enough, the Government Reform Committee. And all three of our committees are looking at and trying to deal with what do we do with two nations, both former classic Stalinist dictatorships that seem to have absolutely no real intent beyond passing laws, but intent to enforce those laws when it comes to intellectual property, when it comes, to be honest, with not spying on us and not taking not just intellectual property in the sense of DVDs and CDs, but technology to do just about anything to improve their economy. And I always want to be careful when I suggest this, but I want to liken back to the Cold War. During the Cold War, we held these two, China as it is today, obviously, and the old Soviet Union, but substantially the Moscow government, we held them to be totalitarian dictatorships. And because we held them to be totalitarian dictatorships, we held them responsible for any and all actions that occurred within their government structure and within anything that might be called a private sector. Any person granted the ability to leave their country, their ships, including their maritime commercial ships, we held them all responsible. Isn't it true that, particularly with Putin's step away from a free market, that Russia now is looking much more like a government that central control is certainly possible, if not always executed. And in the case of China, there's substantially no difference in the organization that we dealt with in the Cold War. A strong central government with strong regional governments, but all of which reported back, in the case of China, to the political structure of the Communist Party. If that's true, and I believe it is, shouldn't we view the Cold War tactic of simply saying to their governments, we hold you responsible, and any failure will be considered to be a willful act? And a failure to make these changes or substantial progress on these changes in a timely fashion should result in an appropriate raising on an economic basis of the curtain that we so long worked viewing in front of us and between us.
Significant changes made.
Mr. Israel, I guess we'll start with you.
Sure. Thank you, Congressman. I think the historical context that come into play with these two countries in particular certainly have to be considered, and I know the entire federal government, the administration, as well as Congress consider these components when you think about how to address the issues going forward. I do think, in addition to some of the things you laid out, one key factor to consider is the significant current presence and potential presence and desired presence of U.S. business and industry working in these markets. These are, as you're well aware, sir, of course, very, very large and lucrative markets, particularly in the case of China, with very large U.S. investments there. So I do think the posture that the United States takes towards these two countries has obviously evolved and changed a good deal over the most recent years as the trading relationship has become extremely intertwined and complex between the countries. And I do think we are looking, and I believe that in the coordination model that we're trying to develop, we are looking to make sure that across the entire U.S. federal government, the relationships that we have with these two countries, when given an opportunity to stress the significance of intellectual property rights, what it means, not in terms of how these two countries view it, but how in terms the United States views it, and indeed most of the industrialized, sophisticated economies of the world view intellectual property. One thing I think that is a bit of a piece of leverage with both Russia and China is they desire to be viewed on the world stage as sophisticated global economies. That can
market economies.
Market economies, to use the common term that we hear quite a bit from both. And their leaders desire that, and we have stressed that there's a certain pattern of behavior, there's rules of law, there's ways you engage in a global economy that fit the norms of the modern economy. And I do think that's something we need to continue to stress with both these countries. And I do think it's an evolving set of relationships, clearly, and there are new rules and new processes we're engaging in and trying to use every opportunity we have across all the relationship venues with these two countries to stress the priorities that we have, IPR being nearly first on every one of those lists.
Sure. In order to focus the answers, because I don't want to monopolize the time, the question really, though, is the government-to-government relationship, not as a market economy to market economy where we say, make your best efforts, but we understand you have an independent judiciary, an independent legislature, an independent business climate, all of which really doesn't exist in China. And I've traveled and done business in China extensively for over 20 years, and now traveled to Russia and looked at the changing Russia. These are not market economies. Business to business, I understand. Government to government, should we hold these governments responsible? And if so, should that message become the obvious message, which is we don't want to hear about best efforts. We expect your government to perform the same as when, during the Cold War, we said, if your submarine drifts outside its zone, we will consider it a provocative action, not an accident, because we expect you to keep your government activities and your fishing boats that used to prowl the West Coast. We expect you to make sure that they obey international law. So the question really is government to government. Ms. Espedal.
Well, I guess to me, the question you're asking is, isn't this really a matter of political will, high-level political will?
Exactly.
And I would agree with you. And I think we understand that with both Russia and China, it is critical that this come from the highest level of their political structure in order to be effective. We have therefore raised it at our own highest levels of political structure, including by President Bush. I'd like to note, in case you aren't aware, that the meetings, I think of the top levels of all the federal agencies and President Bush have produced a statement from President Hu of China saying that he understands and the need to protect the legitimate rights and interests of our right holders, and that this is something China intends to do. I'd also like to note that our understanding is in August of this year, for what I believe is the first time, President Putin actually intervened on this issue and sent a very strong message to his interministerial that this is something that needed to be addressed. And I think you can, and I think that is a primary reason why we have, in fact, seen some recent progress in the last few weeks, because that message is coming from the very top of their political structure now. So I would agree with you that it's critical that it be addressed at that level.
Thank you, Mr. Chairman. I'd ask unanimous consent for the others to respond in writing.
With that objection, would you complete the response in writing then? Thank you, Mr. Issa. The gentlewoman from California, Ms. Waters, is recognized for her questions.
Thank you very much, Mr. Chairman and members. I'm beginning to recognize that this problem of piracy and counterfeit items, et cetera, is much larger than I even thought it was. First, let me just say that whether you're on Fifth Avenue in New York in front of Saks Fifth Avenue or Cartier's, where the knockoff goods are being sold out of bags by immigrants around the clock, or you're in most of the communities, and particularly low-income communities across the country, knockoffs have replaced basically the retail industry in many of these communities. And not only do you have people selling on the streets, you have these huge swap meets that are bringing in the knockoffs from Korea and China and other places, I guess. So when you go to festivals around the country, whether it's in Florida, New York, et cetera, they're selling thousands of Louis Vuitton purses and all the other items that most of us know about. Now, I can simply speculate that we have been very lenient with China and some of our other trading partners, and I do not think they take us seriously. I'm pleased to hear about this new strong relationship we have with Russia, and the fact that they are supposedly shutting down plants and breaking up these operations. But I guess I'd like to ask whomever would like to answer, what evidence do you have that Russia or China is willing to shut down plants, have criminal penalties, and to destroy equipment, et cetera, whether we're talking about in the simple retail industry or with computer software or any of the other areas of concern that we have about intellectual properties?
If I might take a crack at that, just to respond to you, the first part of your statement. In this country, clearly we have piracy, and you described it, but it's a very small percentage of our overall market. It exists. There's no way you're going to get rid of it. But if you go to China and Russia, we're not talking about 3 and 4% piracy rates. We're talking about 90% piracy rates, and we're talking huge criminal syndicates that produce this product. It's a problem of a totally different order. With respect to Russia and the closing of the plants, in fact, just recently they raided 9 plants. And in my testimony, I noted that that's progress. They rated them. But the problem is...
And what happened?
The problem is that product went out the door. They didn't seize the equipment. Historically, there have been virtually no prosecutions of plant owners. There's been one conviction of a plant owner in the last 5 years. This latest set of raids doesn't give us great comfort that there's been significant change. And Ms. Espinel is absolutely right. President Putin did make that statement, and perhaps we will see something. But President Putin and the Russian government have made a lot of statements over the last years, and we haven't seen the action, and we're frankly quite frustrated. And it's a lot of promises and no convictions, no real action that it's going to have a significant on-the-ground market impact for our industry.
May I quickly ask, how has this discussion taken form or shape in the WTO?
I'll speak to that. I just want to emphasize or underscore the remarks made by Mr. Smith. We do see the recent raids of the OD plants as progress, but we have made quite clear to Russia that we need follow-up. We need the equipment to be seized and destroyed. We need the plants to be shut down permanently. We need to see people put in jail. In terms of the WTO the process, right now we and other countries are negotiating with Russia the terms of their WTO accession, and there is an office at USTR that handles those negotiations. We are in the process of doing our bilateral market access negotiations with Russia. When those are completed, there will then be a multilateral process to negotiate the rules of the WTO accession.
Thank you, Mr. Chair.
Thank you, Ms. Waters. Appreciate those questions. Thank you all for your testimony today. It's been very helpful. Obviously, this is an issue we're going to continue to monitor closely, but we appreciate your responses today. And Mr. Israel, you more than survived your first appearance before Congress as a witness. Thank you all again. We stand adjourned.